Bankruptcy is the second topic in Module 3, and it is the basis of your legal analysis problem for this module. The learning objectives are the Bankruptcy Act, Chapter 7 Liquidation, Discharge in Bankruptcy, Chapter 11, which is Reorganizations, Chapter 12, Family Enterprises, and Chapter 13, Consumer Debt. So the 4 chapter numbers are referring to the different types of bankruptcy. Is a federal code, so it applies to all persons legally residing in the United States. And there are federal bankruptcy courts, which are considered specialized courts in every state in the United States. And depending on how populous the state is, there may be multiple bankruptcy courts. The Federal Bankruptcy Code provides an organized procedure for insolvent debtors and is supervised by a federal court. So primary proceedings include the state bankruptcy, which are the liquidations, reorganizations, family farms and commercial fishing operations, and consumer debt adjustments. And we'll look more closely into what each of these types are as we proceed through this PowerPoint. All bankruptcy proceedings begin by filing a petition, either voluntary or involuntary. So voluntary means that an individual has filed for bankruptcy by him or herself or as a couple. And involuntary bankruptcy means that creditors have filed a petition against who owes them money. So a voluntary petition may be filed by an individual, a partnership, or a corporate debtor. And an involuntary petition may be filed by the creditors in an attempt to reach the debtor's assets in lieu of payment on debts. There's an automatic stay, so filing the bankruptcy petition operates as an automatic stay, halting creditor action against the debtor or the property, including beginning or continuing judicial proceedings against the debtor. So if the creditor is going after the debtor that in a court, then there's an automatic stay for this procedure, or this process, this suit. Actions to repossess the debtor's property, actions to create, perfect, or enforce a lien against the debtor's property, and set off of indebtedness owed to debtor before commencement of the bankruptcy proceeding. And once a bankruptcy petition has been filed, the court must first determine that relief should be ordered. And the order of relief is the order that the court issues. This step is automatic for a voluntary petition or no contest of an involuntary petition. If a debtor contests the involuntary petition, then a trial is held on the question of whether the court should grant the order of relief. No contest means that the person or company filed against in the involuntary petition takes no actions, defends it, does not disagree with it. Let's take a look at creditor claims. To participate in the estate of a bankrupt debtor, unsecured creditors must file a proof of claim within a certain time, usually about 6 months after the first meeting of creditors. So basically, once there's a filing of a petition in bankruptcy, the court will notify the creditors that a bankruptcy petition has been filed, and this is how the creditors know there's an automatic stay. So remember from secured transactions that an unsecured creditor would be someone in which there's been no purchase money security interest, no finance statement filed against them. These tend to be things like credit cards. The Bankruptcy Code declares 10 types of claims to have priority over other claims, and these priority claims are paid after secured creditors, but before other unsecured creditors are paid. So secured creditors would be mortgage holders, people who sold you the vehicles, or banks that are holding the note on a vehicle, equipment, whatever you might have. So let's take a look at the different types of priority of claims. There are 10 categories. Domestic support obligations, and this includes child support and spousal support, including alimony. So they are paid between the secured creditors and the unsecured creditors. Administrative expenses, and this includes the cost, fees, and expenses of administering the bankruptcy case. Gap claims, these are debts incurred between the time an involuntary bankruptcy is filed and the date the court approves the bankruptcy filing. An involuntary bankruptcy is a bankruptcy that creditors file against you rather than a bankruptcy you file for yourself. It's less common than voluntary, and the procedures are a bit different. Wage claims. These are employee claims which include wages, salaries, commission, vacation, severance, and sick leave earned. They are limited in amount to $11,725 and in time to those portions of the claim earned within 180 days of the date the bankruptcy was filed, or with 180 days of the date the business was closed if the business was not operating at the time the case was filed. So these are wage claims of employees who work for the business who's now filed for bankruptcy. It can also be in a sole proprietorship if they have people working for them and they don't have a legal entity organized like a corporation or a partnership. They can be wage claims. Employee benefit plan claims. These include amounts owed by an employer to an employer benefit plan and have the same limitations, amount and time as the wage claims. They're only available if the wage claim limits are not fully used. For example, if the employee filed wage claims of $12,475 each and the claims were paid in the bankruptcy, no further employee benefit claims will be paid as a priority for the employees because the priority wage limitation was already reached. Grain farmer and fisherman claims. This is a specialized category and includes claims by a grain farmer against a grain storage facility and claims by a fisherman for the proceeds from the sale of fish. The grain claims are not limited, but the fish claims are limited to $6,150 each, which means per fisherman. Customer deposit claims. This includes deposits placed by individuals for the purchase or lease of property or services for personal or household use when the property or services were not delivered or otherwise received. These are limited to $2,775 per claim. Examples of these types of claims include layaway payments, home repair deposits, and deposits made to travel agencies. So this is where the customer of the business has made these deposits in expecting to receive something in return, like they made the deposit to the travel agency, expecting the travel agency to book a trip for them, or they paid a deposit up front. For example, if Sears is going to come out and look at your refrigerator, or a small appliance company, they take a $100 deposit before they're able to come out and look at it, and then that business goes out of business, then this is one of the priority wage claims in which that $100 is due back to the individual who made the deposit. Tax claims. These include generally taxes which came due within 3 years prior to the bankruptcy filing. Then we have claims for capital requirements due to federal depository institutions. This is a specialized category and gives priority to claims of banks against people or business who are required to maintain the capital reserves of the bank. And DUI claims. These include judgments and monetary claims for personal injury and death as a result of driving a motor vehicle or motor vessel unlawfully while under the influence of alcohol, drugs, or other substances. So again, these are the 10 categories of priority claims that get paid between secured creditors and unsecured creditors. So now we're going to look at the different types of bankruptcy, and they're different by means of who is filing, by the level of credit that they have, the level of debt that they have, that type of thing. So liquidation is the first one we'll look at, and it's called Chapter 7. In a liquidation proceeding or straight bankruptcy, it's probably the simplest. Debtor must disclose all property owned and surrender bankruptcy estate to a bankruptcy trustee. The bankruptcy trustee is a person appointed by the bankruptcy court to oversee the bankruptcy. Usually they are attorneys, but they're not always so. Bankrupt person required to file a list of assets, liabilities, and creditors, plus a statement of the bankrupt's financial affairs. And the trustee organizes and manages the debtor's property and related claims. And the trustee becomes the go-between between the federal court, the creditors, whether they're unsecured or secured, any priority claims, and the bankrupt person or entity. Creditors meet and they may elect a trustee from a list, and the trustee segregates the property that the debtor may keep and then administers, liquidates, and distributes the remainder of the estate. So some property is protected under federal bankruptcy law and some property is not. So the idea of a bankruptcy is allow someone to restart their lives financially and so certain items are protected. Creditors' relative rights are determined by law. A failure of the bankrupt person to file the information that's noted above, the list of assets, liabilities, and creditors, and the statement of their financial position, within 45 days of the petition results in automatic dismissal, though an extension of time is possible. So if the bankrupt person cannot get the information together in 45 days, they can ask for an extension, and it's usually granted unless there's something going on that appears to be illegal. For example, if the bankrupt person is in the process of the 45 days trying to hide assets or distribute assets, put assets in other people's names so it wouldn't be within the reach of the bankruptcy court, then the court will not allow the extension of time. And whether appointed or elected, the trustee sets aside all the property the debtor may keep, takes possession of the debtor's property, and has it appraised, and examines creditor claims, objecting if necessary, and separates unsecured property from the secured and otherwise exempt property. So we pretty much turn your life over to the trustee, everything you own, and they look at it under a microscope. So if we look at the bankruptcy estate, the estate includes all of debtor's legal and equitable interest in property. Exemptions permit the bankrupt person to retain a minimum amount of assets considered necessary to live and necessary to life, and an ability to earn and continue to earn a living. And exemptions vary from state to state, so states are able to affect what's considered bankrupt property, and a debtor may void some liens against exempt properties that impair the exemptions. So the debtors may redeem that exempt personal property from secured creditors by paying the full value of the collateral at the time the property is redeemed. So even though the property is exempt, they can actually take actions to actually own this property outright. And a debtor and creditor may engage in ordinary business transactions during this process. Fraud and abuse is a problem in bankruptcy, as it is in many other aspects of life. So if a debtor transfers property or incurs an obligation with intent to hinder, delay, or defraud creditors, transfer is voidable by the trustee. So again, during that 45 days, before that they list their assets and debts and things like that, if they do anything that is considered inappropriate by the trustee, whatever that transfer is would be voidable. And between the 45 days that they filed their list and any time after that until the order of relief is granted, the trustee can actually go back to the bankruptcy court and let the bankruptcy judge know what's going on. Some people in the past and businesses in the past have started destroying property, which makes the value zero or makes the item worthless, and that's considered fraudulent. And so the trustee can take action against that by going to the bankruptcy court. And the bankruptcy code permits court to dismiss a case for abuse of process if debtor acted in bad faith or had present or future means to pay a significant portion of their current debts. So if they find out that the person has actually planned for the bankruptcy by transferring property just prior to the petition, or is hiding money like outside the country or in other people's names, then that's considered an abuse of process and that the debtor's acting in bad faith. These transfers of property include transfers of property for less than reasonable value, and the dismissal is the means test, determines debtor's ability to repay general unsecured claims, and the means test has 3 elements: a definition of current monthly income, a list of allowed deductions from the current monthly income for the purpose of supporting the debtor and his family and for repayment of higher priority debts, and defined trigger points at which the income remaining after the allowed deductions would trigger the presumption of abuse. You will be looking at the means test in your legal analysis problem, and the means test is based on where you live, rather than liquidated because creditors would benefit more from the continuation of a bankrupt debtor's business than from the liquidation of the debtor's property. And Chapter 11 is available to individuals and business enterprises. So reorganization, we often hear about this with very large corporations such as General Motors, Chrysler, that type of thing. So I think most of the airlines in the United States have filed a Chapter 11 bankruptcy and allows them to reorganize their affairs and still remain in business. Trustee duties under Chapter 11. They develop the reorganization plan for handling the creditor's claim in the interest of persons such as shareholders rather than liquidating the estate. Plan divides creditors into classes. States how each creditor will be satisfied. States which claims are adversely affected by the plan. And provides equal treatment to each creditor in a particular class. The reorganization plan is essentially a contract between a debtor and its creditors and may involve recapitalization or giving creditors some equity. So some creditors, in lieu of being paid down their debt, they might be given some equity like shares in the company so that when the company does get back on its feet, they would have an ownership portion in the company. The bankruptcy plan is the reorganization plan, and it must be confirmed by the court before it becomes effective. And plans may be confirmed by voluntary agreement of creditors or what they call a cram down. That's where the court forces dissenting creditors whose claims would be impaired to accept the plan if the court finds it is fair and equitable to the creditors. So sometimes you can't get the creditors to agree on anything, even though the bankruptcy trustee has done everything in their power to come up with an acceptable plan, and therefore the court forces them to accept it. And then if it's confirmed by the court, the debtor must implement the plan. Next, we'll look at Chapter 12 and Chapter 13. Chapter 13 gives individuals right to file a voluntary petition for federal bankruptcy protection and an opportunity to pay debts in installments free of problems such as garnishments and attachments of the property. So it's a payment plan for individuals. It's not available to businesses. And Chapter 12 is modeled after Chapter 13 and is available only for family farmers and fishermen with regular income. So it's a slightly different type. Again, these are available to individuals and sole proprietorships. Chapter 13, Consumer Debt. Only individuals with regular income, including business sole proprietors who owe liquidated unsecured debts of less than $336,900 and secured debts of less than $1,010,650 may file for Chapter 13 relief. And after filing, the debtor submits a payment plan to secured creditors for acceptance, and if acceptable, the court approves and appoints trustee to implement the plan. And last, we'll look at discharge. A bankrupt person not guilty of dishonest acts and who filled the duties as a bankrupt is entitled to a discharge in bankruptcy. A discharge relieves the bankrupt person of further responsibility for dischargeable debts and gives him a fresh start. And that applies to him or her. And certain debts, including educational loans, are not dischargeable in bankruptcy. So don't get into the idea that, I owe $30,000 in student loans, I'll just file bankruptcy, because you have to pay those off. They're not even crammed down. Okay, so some things to think about for discharge. A corporation or partnership is not eligible for discharge in bankruptcy. Non-dischargeable debts include, among other debts, and these are things that cannot be discharged. For example, we just gave you educational loans. Any monies due as a tax or fine to the United States or any state or local unit of government, so past taxes. Any debt resulting from liabilities for obtaining money by false pretenses or false representations. Any debt that were incurred by the debtor's purchase of more than $500 in luxury goods or services on credit from a single creditor within 90 days of filing a petition, it's presumed to be non-dischargeable. So if you bought a luxury item, let's say you went out, you filed petition for bankruptcy on Monday, June 2nd, and on June 4th you went out and bought a Rolex watch, a real one, then that debt you would still owe. Any debt that are cash advances in excess of $750 obtained by use of a credit card or revolving line of credit at a credit union and obtained within 70 days of filing a bankruptcy petition presumed to be non-dischargeable. Any debts that were not scheduled in time for proof and allowance because the creditor holding the debt did not have notification of the proceeding even though the debtor was aware that he owed money to that creditor. So, for example, that when they the debtor listed in the 45 days their list of assets and debts and that type of thing, even though they knew that that creditor existed, they did not identify the creditor, and therefore the creditor did not receive notice of the proceedings, then their debt is not dischargeable. Also, if the bankrupt person in its list of assets and debts listed the creditor but either listed the incorrect creditor's address or the incorrect amount, then again that creditor is not subject to the discharge. Any debts that were created by the debtor's larceny or embezzlement or by the debtor's fraud while acting in a fiduciary capacity. So if you've done something illegal with the money, even though you have not been charged with the illegality or the charge may be pending, the court will accept that that debt is not dischargeable. And any debt for a domestic support obligation, unless accepting it from discharge would impose an undue hardship on the debtor's dependents. So if you owed back child support, back alimony, you could not get that discharge. Any debt due for willful or malicious injury to a person or his property. Again, any educational loans, any debts which are judgments arising out of a debtor's operation of a motor vehicle while legally intoxicated. Those are the DUI claims. Any debt incurred to pay a tax to the United States that would not be dischargeable. And any debt which are property settlements arising from divorce or separation proceedings other than support provisions that are priority claims. So that's kind of in a nutshell which debts are not dischargeable regardless of the type of bankruptcy that you file for. This includes this PowerPoint, and remember that your legal analysis problem is on bankruptcy, so keep this in mind. Thank you.